SJC-11339, Commonwealth v. Edmund J. Carriere.
Oh, sorry. May it please the court, my name is Neil Fishman. I'm here for the defendant, Edmund Carriere. More than 30 years ago, in January of 1980, Francis Carriere was brutally murdered. In its thirst for justice, the manner in which the Commonwealth prosecuted this crime, certain norms of the adversarial system were short-circuited. I'd like to take, in my brief, I have five arguments. I'm going to take you through 3 points, which really consists of all 5 arguments, but I've kind of synthesized them. The first argument involves the well-known joint venture exception to the hearsay rule. In order for as this court knows, in order for the joint venture exception to apply, you have to find, the jury has to find, by a preponderance of the evidence, that a joint venture has been proven. But the proof has to come independent of the statements which the Commonwealth is seeking to admit, or the party is seeking to admit. Here, there was no proof independent of the hearsay statements that that Stewart was hired, nor was there any proof independent of the hearsay statements that Grabowski was hired. And there was also no...
Except for the fact that the defendant paid them $10,000.
Well, as I argue in my brief, that is, whether that rises to the level of preponderance of the evidence, I would suggest it does, and I would suggest that is a ambiguous thing. It appears from they appear to be criminal associates. There was evidence which is sort of unclear about a lumber deal.
I thought your client, well, the evidence was that your client, at the end of it, brought the $10,000 to these 2 individuals and complained about the fact that they had failed to murder his son and that they didn't like that the body had been discovered. I mean, isn't that direct evidence?
Well, I would direct Your Honor to page 26 of my brief, where I said, regarding the money which the defendant allegedly threw on the table, it cannot be gleaned from the defendant's alleged statements whether the money was payment for the crime or another one, or something else entirely. Put another way, defendant's alleged act of throwing the money on the table did not, in and of itself, prove that it was more likely than not that he was engaged in a joint venture with Grabowski, or Stewart, for that matter, to kill his wife.
Well, that's easy to say, but it strikes me that that's pretty powerful evidence that they were engaged in a criminal conspiracy having to do with the murder of a member of the family who was paying the $10,000.
Well, Your Honor, I would just...
Murder of his wife, we have the murder, and then we have the payment to the individuals who murdered his wife.
I understand Your Honor's point. I would just retort that given the fact that there was some sort of, that they appeared to be criminal associates with one another, and they had dealings with one another, that it's unclear what this payment was for, and that I would just suggest that it doesn't rise to a level more likely than not this payment was for the crime. However, moving on, even if this court find that the joint venture had been proven independent of the out-of-court statements, there were statements admitted that outside of the joint venture exception to the hearsay rule, and I'd like to take the court through these statements. They're on page 27 through 28 of my brief. So first we have, according to Stewart, Grabowski told him 2 months before the murder that he had a deal for him, that he was offering him $5,000 had been offered to him by the defendant to kill his wife. Now, I argue in the brief that this was outside the joint venture exception because Stewart tells us that he said, I don't want any part of it. So, that should have been excluded.
Well, does he
Well,
say?
wait, doesn't he say also that the guy kept at me and eventually I wound up agreeing to do it?
That is true, Your Honor, and,
Doesn't it come in?
well, I mean, there has to be some sort of timing issue here. We have no idea when he finally agreed to do it. There were other, I just want to take your court through these other problematic statements that came in that really don't fit the joint venture exception. Stewart also testified that years prior to the murder, he was involved in stealing truckloads of lumber with Carriere and Grabowski. This is the criminal associate lumber thing that I was talking about. And again, this evidence was outside the joint venture exception. It's also irrelevant.
I think you're probably plainly right about that, but how is this prejudicial in the context of the case?
Well, it's funny Your Honor should mention the word prejudice because, you know, I think what from the defense perspective, what happened here was a woman was brutally murdered 30 years ago, more than 30 years ago. And in the interim, one person was convicted. His conviction was overturned by this court. Another person was indicted. That person, who really is the Commonwealth's star witness, died. And in its thirst for justice...
Well, Mr. Stewart, who is the key witness in this case, was the individual whose murder conviction was reversed for an evidentiary issue.
That's right, Your Honor.
And then he agreed to testify about what he had done and whom he had done it with.
Right. You know, in my brief, I couldn't move in my office without bumping into an admitted hearsay statement in this case. Hearsay statements, as I say in my brief, of every stripe and color were admitted in this case when it came to the Commonwealth's case, right? This case is so replete with hearsay statements that it's really hard to keep track of them all. Admitted hearsay statements. But when the defendant wanted one statement in, he wanted the statement, one or two, but he wanted the statement from Grabowski to Milo, I believe, that I off the bitch. This was the purported statement. And it was going to come in under the exception, statement against penal interest exception to the hearsay rule. The statement should have come in. It should have come in for a variety of reasons.
I can't recall. Was it offered in the first trial? Did it come
There,
in the first trial?
there was some noise about it in the first trial. The distinction is, in the first trial, it was the Commonwealth who sought to admit it. And this court said no, but it was coming in under some different exception, and there were whole entirely different reasoning going on. In this case, this is the defense trying to admit the statement. And, you know, first of all, I just want to say at the outset that this court's holding in Stewart is not applicable here to what was going on here. But I also want to say that the statement satisfied all three requirements of all three prongs of the joint.
But the Commonwealth says actually the third prong was not satisfied.
Well,
And points in particular to, you know, look at the circumstances in which that statement was made. They were Confederates. It's not the kind of setting where Grabowski would have had any reason to think that this was going to be used or taken as something that you know might get to the police or ever be something that would be used in a testimonial fashion.
I understand Your Honor's point. I don't know of any exception. I don't know of any rule that says, with regard to prong 2 of the statement against penal interest, when you're doing this analysis, that, hey, if you have someone who's sort of untrustworthy, then you can assume that let me rephrase that. Actually, I would direct your honor to Commonwealth versus Conway, which stands for the proposition that if you admit guilt, you satisfy the second requirement, right? The second requirement is the statement has to tend to subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true.
So you're saying that the circumstances in which somebody makes a statement like that make no difference?
What I'm saying is if I'm a criminal associate of someone and I make this statement, there's every chance in the world that person one day may testify against me. So I would not make the statement unless it were true. So yes, I think the second prong was satisfied here. The third prong, which really is what the fight's about, the third prong says, the statement, if offered to exculpate the accused, is corroborated by circumstances clearly indicating its trustworthiness. Now, as a threshold matter, I just want to point out that the trial court didn't do any analysis on this. The trial court just said in conclusory fashion, I find that the third prong was not satisfied. In my brief, I give you a multitude of reasons why the third prong was satisfied. I just would want to return to the theme of what's good for the goose is sort of good for the gander here. We have just literally loads and loads of hearsay coming in on the Commonwealth's case. And Drew, the Commonwealth versus Drew, I believe, is a case that stands for a proposition that if the court should be a little bit careful about when it comes to when a defendant is asking to admit a statement against penal interests, a trial court should kind of, not exclude such a statement casually, because after all, there's constitutional rights involved. But I would like to say that the reason that the statement was corroborated, we have that basically, I don't think I need to, they're all there on page 36 of the brief, of my brief. There's a lot of reasons. When I'm speaking about prejudice here, there were huge area of prejudice was various statements that were extremely prejudicial. When it came down to this case, as I said, the Commonwealth star witness was dead. So really this case was, what was going on in terms of the prejudice to the defendant was a huge attempt to paint him as a monster, because the evidence that he'd committed the crime that was problematic. Their star witness was dead. So we have evidence that defendant wanted to kill his son. We have evidence that defendant wanted some big black guys to do things to his wife that she would never forget. These are all statements that were admitted against defendant in trial. Some of them were objected to and some were not. And this is one of these things of chasing down every statement. I made a strategic decision to sort of like put these things together in blocks and say, well, even if we're under the substantial likelihood of miscarriage of justice standard, I think we need a new trial. But they're all, if your court is all concerned about preservation, it's all spelled out in the statement of facts. We have that he said that the mother was a whore and she was having sex with everyone in Cape Cod, and that he didn't attend her funeral, and he acted callously about it. That the son should have been killed, and that the son had had sex with the mother. So these things, whatever probative value they had, I think that it was substantially outweighed by their potential to really prejudice this jury. And that's what I'm saying here is buttressed by the fact that the Commonwealth's closing argument, in their closing argument, they say that defendant, look, he's a bad guy. He is a mastermind. He's a devil. That's not the word they use, in fairness, but I do want to, the word they use is, they say he's a mastermind, a puppet master.
He sort of was a mastermind if you take the Commonwealth's evidence. He set this up and then he took off for Florida with one of his daughters, so he'd have an alibi, and got someone else to commit the murder and paid him $10,000. I mean, Sounds to me like what other word would you use?
I think that's outside the bounds of fair rhetoric. I would just say that their theory of the case was he hired someone to kill his wife. There was a veil of secrecy. He wanted someone else to do the dirty work. He wanted to insulate himself from liability.
Well, all that's true, though.
Well,
Based on the Commonwealth's evidence, he did want to insulate himself from.
I think it was prejudicial rhetorical flourishes. But I would also add
But
that
you mean it doesn't show a motive for hiring somebody to kill?
that motive may have been secrecy, but another motive might have been cowardice. I don't want to do it myself. I mean, there could be lots of motives. So,
But no, I mean the motive being hatred,
oh,
the motive for the murder.
right. Well, I would just return to the idea that with everything else I said, that the potential for prejudice here, that whatever probative value there is in the statements or whatever, that this is a fair inference that one could make from the evidence, I would say when you take all the characterizations in its totality of the Commonwealth's closing argument, I think you have a prejudicial closing argument. But more prejudicial because the Commonwealth instructed the jury. Let me get to it with the court's indulgence and just find it. The prosecutor told the jury that, as a judge of facts, quote, you determine what happened or what didn't happen, and it's for you to determine what versions of events is the correct version. What is it that happened? Well, that's not really how an American trial goes. It's not, hey, you get to decide what happened. It's you get to decide whether the Commonwealth has proved its case beyond a reasonable doubt. And the distinction is important because it's really a burden, as I say in my brief. This was objected to as burden shifting. I say, well, it's a little nuanced. It's more burden diluting because it sounds like more a preponderance of the evidence type stuff. Like, hey, which version has more of the ring of truth? And that's how we decide things. And that's not how we decide a criminal case. Also, the prosecutor.
Standard instruction, by the way? The one you're objecting to?
This was a Commonwealth's closing argument.
Oh.
Yeah, it wasn't
Well,
an
what's the
instruction.
standard obstruction, instruction about what the function of the jury is? You are the judges of the facts, right?
Yeah, but in that context, I don't recall what the boilerplate instruction is. But in that context, when a judge instructs a jury, the standard of proof beyond a reasonable doubt is the heart of the.
Right, but colloquially, the prosecutor's saying you're the judges of the facts. You're the one that decides. You're the people that decide what happened here. Isn't that somehow wrong? That's diluting the burden.
I would say if you just look at the statement is, hey, you get to decide. You determine what happened or what didn't happen. It's for you to determine what version of events is the correct version. What is it that happened? That is not a correct statement of law. It's an incorrect statement.
But it's not incorrect either. And if you can't determine it, if we haven't proved it to you beyond a reasonable doubt, then you have to acquit. But it's not true that it's not incorrect to say that you, the jury, are the ones who are charged with deciding what happened here.
Well, Your Honor, I suppose we could go back and forth on this. I think it's a burden-diluting statement. But I think, importantly, it's also when the defense, the prosecutor also said, what is it that happened? And the prosecutor instructed that the term verdict comes from Latin veritas, truth, and dicta, to speak the truth. And then the prosecutor said, 32 years is a long time, and now it's time for you, jurists, to speak the truth. This is an exhortation, do the right thing. We've been thirsting for justice for a long time, do the right thing. And that has been held by this court to be a...
Yeah, but I mean, the jurors aren't fools. And when they hear something like that, do you really think that they're all ramped up to go out and hang the guy, hearing something like that? I mean, that's sort of pablum.
Well, actually, Your Honor, that's the heart of this appeal, is that the case was thin, so the Commonwealth was out to make the defendant to be a monster. Through all these crazy statements that were made against them, through the closing argument, a burden-diluting instruction on the law from the prosecutor, And this
May I ask you, did the judge give a proper instruction to the jury as to what their role was?
I can't answer that other than to say I didn't notice an improper one.
Did the judge give the standard statement to the jury that what the lawyers say in final argument is not the law, that what I tell you is the law? And then did the judge give the standard instruction on they were the finders of fact?
Again, there may have been an error. If there was, I didn't catch it, so I don't know.
Counsel, I'm sorry, your time is up.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Julia Haller on behalf of the Commonwealth. Just to follow up with that, Justice Ireland, the judge gave explicit, strong, and extremely comprehensive instructions. Defense counsel, when he objected, just said, I want you to give the standard, innocence instructions, and the burden is always on the Commonwealth. And the judge said, well, of course I'm going to give those to you. That's what I'm going to say. And he said, then the judge said, if you have any more objections, come talk to me later. And the defense counsel never came back and talked to them. And I would draw your attention to volume 10, page 1763, where, not 1763, excuse me, 1761, where they're talking about the, who decides, you decide where the truth lies or where the facts lie. And the judge says, well, those words are in there that ultimately it's the jury's, and I'm paraphrasing here, it's the jury's obligation to decide where does the truth lie in this matter. That's part of the credibility instruction, which he's true on that. And he gives that instruction. There's just because the defense counsel can't find an objection doesn't mean there is one in there. The judge gave very comprehensive, not objected to instructions in this case. Excuse me. I would just bring out one point that may be a problem if you are having with the situation with the lumber case. I know there was that kind of, he thought was outside the limit.
This is 3 years before?
It's brought out by the defense attorney. It's first brought out by the defense counsel during his opening argument, and that's, I believe, on volume 6, page 1297. And the defense counsel's whole purpose, his whole theory, and he even does a voir dire of a witness at the very end of the case. You'll see that there's a voir dire of a witness. That his whole theory is that Grabowski has the motive to kill the victim because the victim is talking with the Rockland police about this lumber case, about these other breakings and enterings that Grabowski is involved in, this other criminal enterprises.
So the statements that were admitted with respect to this, were they admitted as statements of a joint venture?
Well, there weren't really statements admitted. It was two of the Brault and Berryman, it's my memory on this, Brault and Berryman testify. The lumber truck goes by and it's being driven by Stewart and Grabowski, and Stewart talks about how he goes in and they steal it, and they have an accident, and I think Berryman is one of the two of them, says it's like Christmas. We go out there and we steal all the lumber, and nobody says a word about anything. And the defense counsel works this in as part of how, and there's also testimony that Edmund Carriere III, which is the defendant's son, which the defendant is saying he wants his son killed as well. There's also evidence that the son is cooperating with the police against Grabowski as well. And so this was part of the strategy of the defense attorney to show that Grabowski, not the defendant, had the more of the motive to want the victim dead.
Well, let me ask you this. A lot of evidence came in. The sort of statements of Grabowski, who was certainly in the middle of this deal.
Right.
Why didn't the judge allow Grabowski's statement shortly after the murder that I was the one who killed her to come in?
The first problem we have with that is defense counsel, and if you give me a minute to find the place, defense counsel admits that, and it's at volume 8, page 55, the defense counsel says, well, the statement that I'm offering now to you is not the same statement that Mello made in the Stewart case. So he's not even going
Statement was going to come in through Mr. Mello.
to come in through Mr. Mello.
Mello said, Mr. Grabowski said that he killed the
Supposedly,
woman.
eye off the bitch. There's no indication, and again, the Commonwealth, as Judge Lenk has pointed out, we don't concede that this is really a statement against penal interest. Okay, technically, because he says I did something, it's a statement against penal interest. But he's bragging to the guy who goes out and breaks into houses for him and steals things so he can sell them. He's a drug dealer. There's absolutely zero chance that this guy Mello is going to go out and rat on Grabowski.
Well, you know, it's the company you keep, of course.
Right.
How could it be reasonable to think that such a person wouldn't rat on you if it was in his advantage to do so? I don't really,
I just
I
think
don't know how to evaluate that.
I just think that in this circumstances, looking at this situation, and obviously these are very fact-specific that you've talked about, I think, in Weichel, or Weichel, however it's pronounced, that these are extremely fact-specific situations. But you've got him boasting. The facts of the circumstances are, he doesn't talk about how he did it, he doesn't talk about his involvement. And as try as he can, defense counsel can't get Mello to say when this happened. He tries to get Mello to say that
Do we need all that in order to have a
Yes, we
statement
do.
against penal interest? Do we need it all?
because it's the circumstances of whether it's true or not, or if it's corroborated. We do need all of that, yes.
Prong?
Yes, it's part of the third prong. It's absolutely part of the third prong.
The trustworthiness?
It's the trustworthiness.
Trustworthiness, yeah.
This is not a close question, okay? The statement, Mello couldn't pinpoint the time when the statement was made.
Well, surely he doesn't have to, well, what does Mello say? Within a few weeks?
No, he just says sometime in early 1980. Now,
Well, early 1980, it happened in early 1980.
right, exactly.
so-
We can't get it any earlier than that. And defense counsel, part of defense counsel's plan is to try and get Mello to say that he and Grabowski stopped at Head of the Bay Road, which is where the victim lives, and that Grabowski got out of the car for about 10 or 15 minutes. And this is the defendant's version of how the victim died. Mello was going to testify to this. As try as he can, defense counsel can't get Mello to say that the day that they stopped at Head of the Bay Road was December 9th. Now, defense counsel puts it in his brief that it was December 3rd or 4th. I'm getting my dates mixed up, I apologize. But he will not. He just says it's sometime in early January they stopped. I'm sorry, January, not even December. It's sometime in early January, and then this supposed eye off the bitch happens a month later, a couple of weeks later. He's no more vague than that. There's no testimony by, as I said, by Grabowski as to his involvement. You know, he doesn't give any information as to how it happened or what he did it or how he did it. It's not made contemporaneous like a confession. Somebody just got arrested, but I did this. I think Weichel talks about that case. Again, Mello is hardly a neutral party in this situation.
Well, I mean, the optics of this, Mr. Grabowski's, who's no longer alive and
Right.
available, but all of his statements are coming into evidence as part of the joint venture and being attributed to the
Sure.
defendant, except this one.
And this is not a joint venture statement.
No, but except this one, which occurs right after the murder, sometime after the murder, that says, I killed her.
And you know, along those lines, if we disagree with you and think it should have come in, what kind of consequence does that have?
If we find it should have
If
come
we
in.
find it should have come in, I suppose you'd have to use he objected, obviously. It would have to be a prejudicial error analysis.
And?
I wouldn't even begin to suggest how you guys should decide this. I think, obviously, I would say no. Why would it do it? The defendant made all of these. You've got the strong evidence against the defendant, including his own statements, which are not subject. Some of them weren't even subject to the joint venture analysis. He's got his own statements of venom and hate and wanting his wife dead, and she's a whore, and she's I want a big black man to do things to her. This shows you just how much he hates her.
Yeah, I understand that, but what about, wasn't there evidence also about the victim here having made comments to her boyfriend about a man from onset threatening her?
That was admitted at the very beginning, and the defense attorney ran that right up the
That would be
flagpole
a
and said, that was Grabowski. The defense attorney ran that right up the flagpole and said, that was
That was
Grabowski.
Grabowski. So taking that, wouldn't it be, very helpful to the defendant to be able to get Grabowski admitting that he had killed?
But he does. He does when the defendant comes and pays them, and if you listen to Stewart, and they're talking about it, and he throws the $10,000 down on the table, and Stewart's like mad. He said, what do you mean you got $10,000? You told me 5. And Grabowski says, hey, I'll take care of you. I got 10, I'll take care of you. Less the 500 you owe me for cocaine, but I'll get you. And Stewart talks about how Grabowski and the defendant's mad because the son wasn't killed. He's mad about the way the victim's body's left. Her body should have been taken out and disposed of so no one would have found it. And Stewart talks about all this time about how Grabowski is the facilitator, and he talks about how Grabowski smooths things over with the defendant. And he's admitted, there's no question that he's involved. What the
Grabowski, I think, isn't the evidence that essentially Grabowski gave Stewart the knife, or am I missing something?
Absolutely. Stewart testifies that he gets a call, and he says, you have to do it tonight because there's evidence that the daughter's down in Florida, the daughter has to come back to school, and they're starting to say, why aren't you bringing your daughter home to go to school? And Grabowski calls up Stewart and says, you got to do it tonight. Stewart comes over. Grabowski gives him a knife, gives him gloves, gives him directions. Well, he's been to the house. He knew how to get to the house, and says, you got to do it tonight. And when it's over, he calls Grabowski and leaves a message, and he says, it's done.
Well, let me ask put it in a slightly different light. What was the disadvantage to the Commonwealth for this statement coming in? I mean, wasn't the theory that Grabowski did do the killing, or he was right there? He was part of the.
That wasn't how it was offered. That wasn't how it was offered. It was.
But what difference does it make?
But because it was offered for the defendant's theory that Grabowski did it all alone, and that this whole thing would show that Grabowski did it all alone, and that's why it was offered.
How would that statement explain that he did it all alone?
He's boasting. I killed it. He doesn't say he did it with anybody else. You turn it around, you say the other way. I did it myself. So then the defendant can say, he said he did it. I didn't do it. So it was used. It wanted to be used.
Wasn't the theory that the defendant paid Grabowski and somebody else to do it?
The theory was the defendant paid, right. But the defendant, how the defendant wanted to use it, the defendant, of course, was denying all of this payment and any of this, and was saying that the defendant wanted to use this to show that Grabowski did it of his own because he wanted the victim killed because she was talking to the police. And when you read, if you read the very end, there's a voir dire of a police officer who went and said, yeah, I was talking with her, and she was talking about these motorcycle guys from around the Plymouth area, and that and there was a very real concern. And that was the defendant's whole theme, was Grabowski did this all alone. And that's why it was offered. It wasn't offered. Grabowski was involved in this. He was the facilitator.
Let me ask you this. I know this may not be of great importance, but was it the government's theory at trial that the co-venturers included Mr. Finney?
Yes.
Really? Okay. And as I recall in the Stewart case, the court ruled that there had been insufficient evidence of Finney being a joint venture.
Well, that was different because the testimony comes in differently. It's my understanding. I'm not as familiar with.
What is the evidence that, short of his own the statements, what is the evidence that Finney was a co-conspirator?
Finney tells. It comes in later. Finney, when he's talking with the police, uses the word himself. He says, I'm the defendant's alibi. I went to Florida because I'm the defendant's alibi. Now, Finney himself uses this word, I'm the alibi.
So does that come in what Finney told the police officer?
It came in with no objection.
Objection, okay. Because otherwise, I can't see how it would come in.
It came in, I believe it came in on rebuttal, it came in with absolutely no
There
objection.
surely would not be a statement made in the course of the joint venture.
That was not, but the statement was, because if you read, I think it's Berryman says, you've got to come home because we got to finish the siding, and Finney says, it hasn't happened yet, I can't leave. So he, if you read in the context of
So
that,
Berryman testifies to Finney's statements.
Berryman testifies to
And that
Finney's
comes
statements.
in because Finney is viewed as a
Finney is
joint
viewed as the
venture.
joint venture as part of the alibi. He's down there saying that, that I'm here. It's just another alibi witness for him to say that he was in Florida and not around when the wife was killed.
Okay.
And if there are no further questions, and if I just may add, Chief Justice, it's been an honor and a pleasure. Enjoy your retirement.
Oh, aren't you nice? Thank you very much.
Thank you, Your
Thank you,
Honors.
Counsel.
All right.